Hello, everyone. We want to thank you so very much for signing on today. This is the Indiana Civil Rights Commission Agency Overview. This is brought to you by the Indiana Civil Rights in partnership with IHCDA. My name is Kylie Kramer. I serve as the Public Outreach and Education Manager for the Indiana Civil Rights Commission. And this is my colleague.
I'm Tracy Richardson, the Director of the ADR and Compliance Department and a staff attorney with the Indiana Civil Rights Commission.
Today, we're going to go over the Indiana Civil Rights mission and jurisdiction, life of a complaint, intake, investigation, mediation, litigating with ICRC, and case law update as well. We're going to quickly cover the cultural commissions that we have here under the Indiana Civil Rights Commission. So we have the Indiana Commission on the Social Status of Black Males. The ICSSBM continues to address the challenges confronting Black males while trying to aid in decreasing the problems they face in areas of criminal justice, education, employment, health, and social factors. The Indiana Commission for Women has the mission to understand the needs of Indiana women and their families and to work strategically within government and in our communities to help provide a positive solution. Indiana Commission on Hispanic and Latino Affairs, ISHLA, is a nonpartisan state agency working toward economic, educational, and social equity for Hispanic and Latino Hoosiers, including promoting cooperation and understanding. The Indiana Native American Indian Affairs Commission studies and makes recommendations to appropriate federal, state, and local government agencies in areas of concern to our state's Native and non-Native people. Going further into our Indiana Civil Rights Commission purpose, we are here to enforce, investigate, and educate. Enforcement can be these trainings, as well as our laws that we enforce throughout fair housing. Investigation can be the life of a complaint, which we will go into further. And education is as simple as these trainings and external affairs with their website and social media. So our jurisdiction here at Indiana Civil Rights Commission is allowing us to enforce the Indiana Civil Rights Law, the Indiana Fair Housing Act, and Title 910 of the Indiana Administrative Code.
So, and just to clarify, our administrative code provides us the administrative guidance on how we actually enforce the Indiana Civil Rights Law, as well as the Indiana Fair Housing Act. As Kylie mentioned, enforcement begins with everything from the filing of a complaint within our intake department to the processing of that complaint, a finding of jurisdiction, if we have jurisdiction over those complaint facts in one of our 5 enforcement areas, and the complaint is based on one of the 7 for the Indiana State Civil Rights Commission areas of protected classes. The complaint may go through investigation. It can additionally go to mediation. If there is a finding and it is not mediated and settled, if there is a probable cause or reasonable cause finding, it can go to litigation, where a complaint may be litigated and liability can be found.
Briefly going over what we do here at ICRC, our biggest purpose here is to eradicate discrimination in Indiana. So when we think of discrimination, we might think of the word prejudice or bias or racism or the civil rights movement. Sorry. So we can ask you in the chat what else you may think of, but while you're doing that, we're going to move forward. So these are just some words that people may think of, and if you want to broaden them as well in the Q&A section chat, you are more than welcome to do that as well.
So also at the Indiana Civil Rights Commission, it is unlawful discrimination that we have jurisdiction over. Of course, discrimination can take many forms, but if you do meet one of our enforcement areas, if you're governed within one of our enforcement areas and you're discriminating against them, we will speak further about this. Any of the protected classes within the state of Indiana, that becomes unlawful discrimination.
And going further in depth of what discrimination is, this is the, I'm so sorry, I need to pause this.
You know, I,
I just feel like this is just not the same and it feels so different.
you know what? This is what one thing I noticed is you kind of forgot because there's quite a lot of conversation. Well, this one didn't have it, but like,
Yeah,
there's a,
I don't want to like read it from there. And that's like my
but
biggest
you can
thing.
take it, like you're not really reading it, or just take, you know, what you like from
Yeah,
there.
because I noticed we were going, like, it's only been 8 minutes in this thing.
And we're almost done. No, I'm just kidding.
No, but like actually. Oh my God.
I don't know.
I'm so
Is it not
sorry.
working?
No, it just, Hello and welcome to the Indiana Civil Rights Commission Agency Overview Training. We would like to thank the Indiana Civil Rights Commission for partnering with IHCDA to allow these trainings to even happen. My name is Kylie Kramer and I serve as the Public Outreach and Education Manager here at the Civil Rights Commission in the External Affairs Department. And this is my colleague Tracy.
My name is Tracy Richardson. I'm the Director of the ADR and Compliance Department. I'm a staff attorney with the Indiana Civil Rights Commission.
So our itinerary is going to be discussing the ICRC mission, jurisdiction, life of a complaint, the intake, investigation, and mediation process, as well as litigating with ICRC and case law update.
And we'd just like to say, before we get started, we'd like to give a disclaimer and let you all know that this is not legal advice. It cannot be deemed legal advice or relied upon as legal advice. If you have any questions about anything under our Indiana civil rights laws or Indiana Fair Housing Act, or even our administrative guidelines, we just advise you to seek the services of a licensed attorney in the state of Indiana. This is purely for educational purposes.
Yes, and then we also like to mention that there will be 2 5-minute breaks during this presentation to allow you to digest all this information and ask questions later during the Q&A section as needed. So I would like to discuss our 4 cultural commissions that are under the Indiana Civil Rights Commission. So our first one is the Indiana Commission on the Social Status of Black Males. They continue to address the challenges confronting Black males while trying to aid in decreasing the problems they face in areas of criminal justice, education, employment, health, and social factors. 2020 marked the 27th anniversary of the commission. The Indiana Commission on Social Status of Black Males is committed to helping build strong Black men in 5 focus areas, as I have discussed. And the next one is the Indiana Commission for Women. Their mission is to understand the needs of Indiana women and their families, and to work strategically both within government and within our communities to help bring about positive solution. It is their hope that they can keep moving forward by encouraging women to retain and become more educated and become more connected within their communities. This will also aid in being more aware of their opportunities and resources available to them, and to start a business and step forward as leaders in their communities. The Indiana Commission on Hispanic and Latino Affairs, ISHLA, is a nonpartisan state agency working toward economic, educational, and social equity for Hispanic and Latino Hoosiers, including and promoting cooperation and understanding. This commission identifies, measures, and reviews programs and legislation, and researches challenges and opportunities affecting the Hispanic/Latino community. The commission identifies solutions and provides recommendations to our governor and our legislators all across the state. The Indiana Native American and Indian Affairs Commission studies and makes recommendations to appropriate federal, state, and local government agencies in areas of concern to our state's Native and non-Native people. This is a community that is pleased to join community leaders and partner organizations to share month-long celebrations of history, heritage, culture, and current affairs as we recognize November as Native American Heritage Month. Now looking into ICRC, we enforce, we investigate, and we educate. Again, as Tracy has said, we are not lawmakers. We just enforce the law, as she will go into later in a different slide. We enforce the civil rights laws of the state of Indiana, and this starts with a phone call to our office, and then this starts to stage an intake, and we'll go over a complaint. And then it goes to enforcement. And it goes to investigation, in which we look at complaints of discrimination. And then it goes into education. And this is with organizations, companies, landlords, associations, individuals on their rights and responsibilities with the Indiana Civil Rights Commission.
And so, as we discussed earlier, when we went through our commissions, our External Affairs Department provides the majority of that education to different communities so they understand the services that the Indiana Civil Rights Commission provides. But as we go into this portion, we're talking about what's called our operations department. And that's where we enforce the actual civil rights laws that we were created under. And as Kylie mentioned, we may investigate laws being, complaints being investigated, may also go to mediation. They could even go to litigation if there's a cause, a probable cause, or a reasonable cause finding. So the Indiana Civil Rights Commission is kind of an agency that takes a complaint, as some people may call it, from the cradle to the grave or from the beginning to the end. A complaint can commence with us and it can end and be closed with us, whether that's ending through a finding of not even needing to go to investigation because it's not jurisdictional for us, or if it's investigated and there's simply not a probable cause finding, it may be closed there. It could be mediated and settled, which would result in a closure, or it could be investigated, sent to litigation, and then litigated, where there could be a prevailing on behalf of the agency and the complainant, or a prevailing on behalf of a respondent. And at that stage also, there's a closure unless, of course, there is an appeal of finding. But our agency takes the life of a complaint through many processes under our Indiana civil rights laws.
And this goes along with our next slide, which discusses the Indiana Civil Rights Commission enforcement. And this is with the Indiana Civil Rights Law, the Indiana Fair Housing Act, and Title 910 of the Indiana Administrative Code. So this is a question that you can answer in your Q&A section. When people usually think of discrimination, they think of prejudice, bias, racism, or the civil rights movement. And we are more than welcome to discuss those in depth in the chat if you wish to do so. But definitely take this moment to reflect on some words that you can think of when you think of the word discrimination, because there is a flat law discrimination definition, but to some people it means more, and they have some more connections to it.
So under our laws, also discrimination, of course, when people think of discriminate or discrimination, you can discriminate in many areas. What we have jurisdiction over is what's called unlawful discrimination. And that's when a preference is given for an unlawful reason. And those reasons are found in our protected class statuses. So making preferences in areas of education, in areas of employment, in areas of housing, in areas of credit, in areas of public accommodations under the Indiana civil rights laws. If those preferences are made, and they're based again on what are called our protected class statuses. And I'll just discuss a few. They could be race, they could be sex, could be disability statuses. And we're going to talk further along more about those protected class statuses. But unlawful discrimination is making preferences on what some people call immutable characteristics, things people can't change about themselves. That's when we come and meet unlawful discrimination. And that's what the Indiana Civil Rights has enforcement authority over.
And as I said earlier, there's a discrimination definition, and this is it that we were discussing. And just as Tracy said, we cover in the next slide, we'll talk about it, but our protected classes, which are things that cannot be changed about a person. But going into our definition, discrimination is the prejudicial treatment of an individual based on their membership or perceived membership in a certain group or category, as she was saying, like the color of one's skin. It involves the actual behavior towards groups such as excluding or restricting members of one group. So this goes into our protected classes, and not all discrimination is against the law, but in Indiana, a person may not be treated differently because of their race, religion, color, sex, disability, national origin, ancestry, familial status in fair housing, veteran status in employment and public accommodations, and age. And that's transferred to EEOC. The Indiana Department of Labor also has jurisdiction over this as well. So this is a quick thing that we are also, again, this is an interactive training. So you can put this in your Q&A section. But true or false, is this sign on a door of a restaurant discriminatory? And we'll give it a second, then we'll have Tracy analyze it.
Well, and ask yourself, because we never give yes or no answers. We give that lawyer's answer of it depends. But if you look at it, the question you may want to ask yourself is there a preference against any of the protected classes that are protected within the state of Indiana? Is there a preference for one of those immutable characteristics that is covered? And so if you see that, if kind of an ordinary person would think that's an indication that maybe only females could work as wait staff in this restaurant, that could very potentially create a sex filing complaint based on sex. And of course, sex in the state of Indiana doesn't just cover sex against women, but men as well can file a sex discrimination complaint.
Which is a great analysis. And now we're going to go into our enforcement areas. So the Indiana Civil Rights Law gives ICRC jurisdiction to enforce equal opportunity for all in 5 enforcement areas, which includes housing/real estate, employment, public accommodations, credit, and education. So we're going to take a quick minute break right now and allow you to answer and ask questions in the Q&A chat. This will allow you just to absorb all the information so far before we go into the life of a complaint at ICRC. Please let us know if you'd like us to go into depth about anything so far. All right, welcome back. We are quickly going to go back to the last slide to discuss some exemptions, which are very important to discussing our enforcement areas. And Tracy's going to go over these.
So we're just gonna touch on briefly some examples so you kind of understand what we're talking about when we talk about housing and real estate. So generally, our Fair Housing Act covers everyone. It can cover an owner of apartment complexes, unless you have an exemption, which are exemptions found in our Fair Housing Act. We can talk about them. Single family type housing owners, we have what's called a Mrs. Murphy exemption. We have private club and religious organization exemptions, but you need to fall under those specifically. So it would be important that you find out what those exemptions and guidelines are. But no one is completely exempted from our Fair Housing Act because there are components of that act that can cover anyone. The coverage is designed or defined as covering a person, and that also could include some business entities such as corporations or partnerships. So anyone really, and individuals as well. So anyone can fall under our Fair Housing Act. It does as well cover residential real estate transactions. So realtors or organizations that provide credit services to individuals seeking housing. Anyone that touches on the area of real estate fair housing over individuals could fall under our Fair Housing Act. Employment for the state of Indiana, if you have more than 6 employees. For some of our disability legislation, it would be 15. For public accommodations, obviously the coverage is for any individual. We don't have a specific PA definition in the state of Indiana, but we follow federal guidance on public accommodation definitions. Credit, we cover again, the majority of our cases are in the area of housing when we do credit, but credit can cover the gamut of credit situations. The Indiana Civil Rights Commission can have jurisdiction over if there is discrimination found in credit practices. Additionally, we cover education. And in our areas of education, we do not cover what is covered by the Department of Education. Some individuals file complaints thinking that we have some governance over their child's IEP. We generally do not have governance over that kind of document, but we may have governance over discriminatory actions of a school that may affect particularly children with disabilities. But any type of education complaint under any of our protected classes in the educational setting, anywhere from the early education setting to the university, could be covered under our statute.
And now going into a complaint process here at IUCRC. So this is just a very basic feedback loop, basically, of what you're seeing. There's so many more details and definitions that we will go into later, but it all starts with intake and then goes to investigation, litigation, and then ADR, which is Tracy. One thing to note is that mediation can happen at any time throughout this process that you are seeing. So it starts with intake, and we also call them our first responders. They will do field calls, emails, letters, web inquiries. They build and maintain the cases and assign cases to our investigators, which is the next step. They are the ones to draft the formal complaint with you. So if you call the Indiana Civil Rights Commission or go through our portal, it'll start with them. You file with a permanent residency that is actually not required. So you can actually be a Hoosier, and then you can be someone passing through the state of Indiana. The Civil Rights Commission still has jurisdiction over anything that is going on in here, even if you are a permanent resident or just passing through. Timely complaints, the Fair Housing has 1 year. The Indiana Civil Rights Act has 180 days in employment cases. One thing to note is to document everything, which is what we'll discuss later in a slide. Everything should be documented, and it should be times, dates, people that were there, things of that nature, really to help build your case and help your intake specialist help you out and just make this even more of a case to push forward. So as you can see, the process is document initial contact and intake interview, meets all the prima facie elements, drafts the complaint, sends complaint to complaining party to sign and return to ICRC, and is now a formal complaint.
Yes, and we can take, as Kylie mentioned, a complaint as a direct inquiry, which means you could call in, you could go to our website, you could write in, anyone can file a complaint with us. We do get some complaints from federal partners such as EEOC in the area of employment. We have a work share agreement, and we will take complaints that have fact scenarios that fall under our state statute and our jurisdiction. We are also a partner with HUD, another federal partner, again, a work share agreement. Same thing, they may forward to us fact scenarios that would fall under our state jurisdiction. We may take that complaint as well. We can additionally be referred complaints from local human relations commissions. We do have a number throughout the state of Indiana, and we can also file what are called director initiated complaints. And those complaints can be filed when there is a finding based on a complaint that there's some other discriminatory behavior that is obviously, or that appears from our investigation is going on. And we also engage in testing programs, which allow us to file director initiated complaints. So we have statutory authority in both our Indiana civil rights laws as well as our Fair Housing Act to also file on our own director initiated complaints when it has come to us that potential unlawful discriminatory behavior or conduct. And that's generally in the form of policy is being engaged in.
So again, the biggest thing is just to document when you come and talk to an intake specialist or call in or things of that nature for ICRC. The biggest thing they're going to ask is for your documents and documentation. Interactions with ICRC, attendance policies, how you train employees, interactions with tenants and prospective tenants, all of that would help build a case. So the complaint process is quite lengthy, but it's just going over so many details, and everything works together to make sure that we can file this complaint. So, and that's how it starts, is with intake is filing the complaint. Investigation is answering the allegations. Mediation is having the two parties sit down and try and find a resolution. No cause findings, appeal available. Probable and reasonable cause finding, administrative hearing or state court election, final order from the commission, and appeals directly to the Indiana Court of Appeals.
And yes, that is pretty much the anatomy of the complaint process. And as Kylie mentioned, there are steps that go throughout the process. Intake, again, that is where we establish jurisdiction based on what an individual who is called in says occurred. And if it sounds like something that falls under our laws, we will take a complaint, take jurisdiction, and assign it to an investigator. They will do the investigation. They have the authority to conduct discovery. They have subpoena authority. She mentioned mediation. At any process, mediation can occur. It can occur anywhere after it's been assigned to an investigator. So if both parties would prefer to settle that particular complaint prior to a finding, or perhaps during the litigation process, they have the ability to do that. They may engage in mediations at both stages of the process. We leave mediation open. It's favored in the Indiana Civil Rights Commission to resolve a complaint or a dispute by mediation and settlement if at all possible. However, if the complaint continues through the process, there could be a no cause finding if we don't find that discriminatory act that as alleged occurred. There are appeal rights available to complainants who believe that finding is not correct. Again, probable and reasonable cause findings, reasonable under our Fair Housing Act. You can additionally, if you are in fair housing, you can actually elect to have your case taken to the trial state courts within a certain number of days, as opposed to having it addressed in the administrative forum. Once appeal time constraints have gone through, the commission will issue a final order after an ALJ has looked at the case. If it's been brought to the ALJ, a final order will be issued by the commission. And after a commission order, there are some appeal rights directly to the Court of Appeals for an individual that disagrees with a finding of the agency. But we do engage in a complete process, again, from the very beginning, potentially to the end. If the case does go to the Court of Appeals, generally our attorneys will work with the Office of Attorney General in that area. So we touch just about every area of a complaint filing. And just for individuals to understand, once there is a complaint filed in jurisdiction established, it's not just a complaint on behalf of that individual, but we are proceeding as an agency on behalf of the public's interest. So as is our mission to eradicate unlawful discrimination, we are seeking to ensure that type of behavior, if it truly is unlawful discriminatory behavior being engaged in, is not only vindicated, but also that some education occurs that prevents it from occurring again.
And as Tracy did say, we are going into our next step, basically, and that's investigation. So they are the ones who do the more in-depth interviews, the subpoenas. They request more documentation and very much highlight the importance of the documentation. The parties must stay in touch with the investigators. This is a very important aspect of investigation. They inspect property, attempt conciliation, analyze evidence, and they are allowed to dismiss or default as well. Investigation occurs after jurisdiction is established in intake. An investigator will determine the violations and can grant the authority to conduct the discovery and issues of subpoenas by the commission. Investigators can also decide probable cause or reasonable cause findings after they are approved by the executive director or the deputy director as well. This also goes into REPACE, which is our real estate, fair housing, public accommodations, credit or education, and employment. So those are split into two. They are, one is HUD and then one is EEO, or HUD and EEOC. ICRC acts as a federal partners agent in Indiana. And things to also note, not providing documents can result in a dismissal or default on the claim. It is not the same as litigation. The investigator is neutral. That is a very big part of their job, is to remain neutral. Again, we are not an advocacy
organization unless we are at the litigation phase. But throughout complaint filing, from the beginning, from the inception, when you originally file your complaint, establishing jurisdiction is only us saying we have jurisdiction under the fact scenario that was alleged based on our statutory laws. It is not saying we believe something occurred, because we are impartial throughout the process.
And then one thing to note also is through conciliation, this is not admission necessarily, but the acknowledging that something had occurred. Any conciliation of affirmative relief in public interest, which is training employees, for instance. Also, other things to note, that not providing documents can result in dismissal or default. As we have said, it's just very important to know that this is not the same as litigation, and it is extremely imperative to know that this is a very neutral part of the complaint stage. And helping the investigator in the fact-finding process means that you are providing documentation. Again, documentation is very important in this phase.
And that's key, even not just for a complainant that's filed a complaint, but as well for a respondent who's had a complaint filed against them. Some respondents think if they avoid it, it will go away. They want to fight requests because they think it'll make it go away. But we remind respondents that you may actually exculpate yourself. You may help yourself. The more cooperative you are with an investigator, if you truly believe you have not engaged in a discriminatory practice, providing those requested documents, whether it's policies and procedures or specific types of files in your place of business, can be very helpful in showing that. So it's not only important for complainants to work with the investigator, it's equally as important for respondents to work with the investigator, because again, that investigator is an impartial fact finder, and they are looking for the truth. They are not looking to build a case. We don't build cases, we simply discover facts.
So notice of findings. This is a representation of the claims the Indiana Civil Rights Commission will litigate. A general notice concerning rights and obligations. And this initiates the litigation process if it cause finding. If no cause finding, it may be appealed. What this notice of finding is not, is it is not legal advice. It is not a complete overview of all the facts found by the investigator. Again, with the appeal, that means no finding, so you can appeal this. You have 15 days to file, and the commission revisits and can either uphold the no cause finding, send back for further investigation, or they can overturn and find probable cause. This is the litigation part. So the election is when they move the case to the state court. All parties must agree to elect. Election may be made at any point before the initial pre-hearing process.
But in fair housing, it only takes one party to decide to elect. So if one party in a fair housing case states they would like to elect to move, that case will be moved to state court. Under our Indiana civil rights laws, both parties are required to consent to elect.
Thank you for clarifying that. And then mediation, again, as we've kept reiterating, mediation services are offered throughout this entire process. They may settle a case with respondent attorney or bring the case to a formal mediation.
And mediation services are provided free of charge.
And then this is all Tracy's department, so I'm going to let her speak on this.
Again, as we discussed, mediation can occur throughout the process, can be pre-cause, and that's while it's in the investigative phase. Our mediators may do that mediation. The complaint then would be resolved prior to a finding, and the case is not in litigation at this point. It is important to note, though, that the case can and generally will still be investigated. It does not mean that any of the guidelines for returning documents, particularly if they're statutory, can be held up. Statutory guidelines have to be followed and the investigation can continue. But if you do choose to mediate during the investigative process and both parties come to an agreement, obviously that will close out the case once all the proper documentation is submitted. So it is a great way to resolve a dispute. We try to ensure that parties have an opportunity to kind of clarify issues or clear up any misunderstandings. Mediation in the last year, for the year of 21, I believe we had an 82% mediation rate based on the number of cases that were requested to be mediated. So approximately 82% of them were mediated where an agreement was found or some type of way to resolve the dispute was found. So mediation can be very successful. Mediation can be post-cause as well. When that occurs, the parties are the complainant. Respondent can be ICRL in fair housing cases. The legal staff at that point is involved because at that point, If we have made a finding, we do work on the advocacy side and litigation. So again, it can occur even during litigation. Same thing, parties have an opportunity to resolve a dispute. It's more in certain parties' interest to mediate at that point. It could be. It could avoid many of the expenses and burdens and time of litigation. So again, mediation can be a very successful and good way to resolve a dispute.
And this goes into some non-monetary terms and settlements. So this can include training for respondents, employees, revision of respondents' policies and procedures, neutral reference letter, neutral tenant letter, reinstatement, a letter of an apology, or credit for rent.
And just to remind, for purposes of fair housing, we do follow a very specific compliance agreement because we are under HUD guidelines when it comes to settlements. And so there are some requirements in that conciliation agreement. Some of them are very simple, the names of the parties, that it's written, the date, effective date of the agreement, the terms of the agreement. But affirmative relief in the public interest is also required to be in a conciliation agreement. A conciliation agreement has to be signed off on by our Fair Housing Agency Partnership representative. So it's very important that those components of what a conciliation agreement are guided by HUD guidelines. Those for any individual that engages in a fair housing settlement will follow. So we do settlements for all of our enforcement areas, but we do have some guidelines when we do fair housing settlements.
So we are going to take a quick 5-minute break. This is your last 5-minute break. So please digest all the information so far. We are going to go further into the life of a complaint at ICRC. Please let us know if you have any questions or anything in the Q&A section. We'd love to go more in depth with them later on. Thank you so much for being so interactive this far, and we will see you back in 5 minutes. All right, we are back. And now we are going to look into no cause findings. So complainant may appeal a no cause finding within 15 days of receipt of notice of findings. They can present new evidence, but it is not always necessary. A commissioner will be appointed to review the appeal, and the commission will be able to make a decision to uphold, refer back to investigation, or reverse the notice. Commissioners will also vote on the decision.
So that is where an investigator has found that there was no cause to say that a discriminatory act occurred. And again, if you as an aggrieved person feel that there was cause and you disagree with the decision of the investigator, you have the right to appeal that decision. And that is the process for that.
And then contrary to that is a cause finding. So election is move the case to state court. All parties must agree to elect unless, like you said, it's just one for housing.
Yes.
Election may be made at any point before initial pre-hearing conference. Bench trial is only in state court proceedings. An aggrieved person can make a decision of their own if they elect to go to state court. And then mediation, again, free mediation services are offered at any point throughout the lifetime of a complaint. The ALJ may order mediation and continue to be encouraged at every point within the process. And then with litigation, after cause finding, a case will be assigned to an ICRC attorney. And fair housing, the director of ICRC will become the complainant. In all matters, ICRC litigates with the interest of the public. The ALJ forum versus the trial court, and the AOPA and the Indiana trial rules will apply.
So in litigation, as discussed, the director of the Indiana Civil Rights Commission, if there is a reasonable cause finding, and that is in the area of fair housing. So if there was a complaint, an investigation was complete, and that investigator did find reasonable cause, at that point, the director of the Indiana Civil Rights Commission actually becomes the complainant in the matter. Our litigators will litigate that case again in the interest of the public. The aggrieved person actually has statutory authority if they desire to intervene, or they could simply be a part and an observer of that particular case. The case, again, can be tried in our administrative law judge forum, but can be removed to the trial court as well. The Administrative Orders and Procedures Act obviously governs our administrative forum. Indiana trial rules do apply. There are many Indiana trial rules, such as summary judgment motions and other proceedings under our administrative guidelines that follow trial rules, both discovery, subpoena authority, those type of processes within litigation apply in our administrative forum, the same as they would in the trial courts. Again, for all other areas under the Indiana civil rights laws, both parties must agree to elect to be removed to state court.
And again, this is where we do not become neutral anymore. We are litigating. And if there is a monetary award because we have prevailed in litigation, the aggrieved person would receive such award. And then going further into litigation, the decision will be rendered by the ALJ. The commission will affirm, modify, or dissolve the ALJ order, or may remand with or without instructions to the ALJ. A non-prevailing party has 15 days to object to the decision. And then once the commission affirms the ALJ order, it becomes final agency action and can only be appealed within 30 days from the final order to the Indiana Court of Appeals.
And of course, if there was an election made, it would obviously be rendered by the trial court judge. But again, the process, the commission either affirms, modifies, or dissolves that finding.
And then here are some statistics from our 2020 review of where our cases have fallen under. So as you see from the graph, you'll notice that the majority of our complaints filed fall under protected classes of race, with disability very close behind. At times, disability has been our leading complaint file. Sex discrimination consists of a large number of our complaints filed as well, with 22%. And then obviously familial status findings are only going to be in fair housing.
Yeah, we think it's kind of it's notable that although they're only at 4%, there's only one enforcement area that we have familial status filings, and that would be fair housing. So we do the Indiana Fair Housing Act. So we do think that is kind of notable that they do take that percentage, because they are in none of our other enforcement areas. So something to be on guard about, something to get some information and think about as you develop policies, procedures, and training of staff.
And then moving forward, we will enter into our Q&A session. So we will look over our questions that we have. We're cutting this part out. And then for any further information, if none of your questions were answered today, please feel free to contact me or the Indiana Civil Rights Commission. Again, I serve as the Public Outreach and Education Manager. So you have my work cell phone number and my email right there. And then if you want to call the Indiana Civil Rights Commission for any of your questions or to get in contact with Tracy, you can call us at 317-232-2600. Again, I want to thank you so very much for participating today and being so interactive and following along as we discuss what we do here at the Indiana Civil Rights Commission, as well as how a complaint really falls through our commission. And I would like to thank Tracy as well for being a part of this. Thank you so much and have a great day.